Ever heard of freedom for beliefs and religion? It is always a debate to which one is right. Either Catholic, INC, Jehovah, born-again Christians, etc. The list could go on and on, but it is included in our Constitution, as accommodated in the Free Exercise Clause on religious exercise. More so, in the case of Estrada versus Escritor. Disclaimer: our views on laws are based on actual cases. The facts stated have been made public via publications in the internet. Therefore, should any details, especially of the petitioner and or the defendant, offensive in any way whatsoever, kindly leave a comment or message us in Facebook and we will be more happy to oblige. In the case of Estrada versus Escritor, not only covers the constitutional standing of religious freedom, it also gives weight in balancing the state interest in the nature of marriage. On July 27, 2000, Alejandro Estrada filed a complaint with Judge Coiles against court interpreter Soledad Escritor for living with a man not her husband and having a child him of despite being married to another man, and his live-in partner Luciano Quiliapo Jr. married to another woman. Escritor testified that she was already a widow when she entered the judiciary in 1999 and that her husband died in 1998. She admitted that she started living with Luciano Quiliapo Jr. without the benefit of marriage more than 20 years ago, when her husband was still alive. She also admitted that she and Quiliapo had a son. She also admitted that Quiliapo was also married to another woman. But being members of the religious sect known as Jehovah's Witness and the Watchtower and Bible Tract Society, they were able to contract a conjugal agreement in conformity with the religious beliefs and has the approval of the elders in their congregation. On July 29, 1991, they executed a declaration of pledging faithfulness. This declaration may only be entered by parties who wants to enter a marital relationship with the person belonging to the same religious sect, but cannot contract due to such legal impediments. However, witnesses from the congregation attested that an investigation will be first conducted by their members to check whether or not the parties contracting the declarations are already separated from their spouse. In the case at bar, the congregation found out that Escritor is separated from her husband, who was another woman, and Quiliapo is also separated from his wife. Hence, they were qualified to execute the declaration in conformity to their religious belief. The issue now is whether or not Escritor is guilty of immoral conduct for living with another man, not her husband. Held. Pursuant to the freedom of religious clause of the Constitution, the law recognizes actions which are in accordance to religious belief. Escritor executed a declaration of pledging faithfulness in conformity with her religion. Jehovah's Witness, based on the Bible, which Jesus says those who are victims of unfaithful spouses can execute the pledge. Escritor is not guilty of immoral conduct and her conjugal agreement with Quiliapo is valid. A pledge of faithfulness was issued 10 years prior to her service in the court and executed not to avoid punishment. It bears to emphasize that the image of the court of justice is mirrored in the conduct, official and otherwise, of the person who, thereafter, from the judge to the lowest of its personnel. Court personnel have been enjoined to adhere to the exacting standards of morality and decency in their professional and private conduct in order to preserve the good name and integrity of the courts of justice. It is apparent that the OCA or Office of the Court Administrator reliance upon this ruling that the state interest it upholds is the preservation of the integrity of the judiciary by maintaining among its ranks a high standard of morality and decency. However, there is nothing in the OCA's memorandum to the court that demonstrates how this interest is so compelling that it should override respondents' plea of religious freedom, nor it is shown that the means employed by the government in pursuing its interests in the least restrictive to respondents' religious rights. Here, the Supreme Court emphasized the so-called benevolent neutral approach.